everyone, and thank you for joining us today. I can see that there's going to be people continuing to join, so we'll just have a quick introduction. My name is Sharon Auld. I am Head of Legal Services at Neathouse Partners. I'm sure a lot of you are aware we offer employment law and HR retained work. Seeing a significant increase in queries at the moment, and hopefully today's webinar will help you somewhat in applying the new law changes, etc. Saul is in the background, our marketing manager. He will be fielding questions. If I can ask if you can keep all questions until the end, if possible. As a lot of you who have been on one of my webinars before know, I get terribly distracted if questions come in the middle. So today I'm going to take you through what actually comes into force and has come into force in April under the Employment Rights Act. You're probably all aware of the changes that have come through, but just to advise, excuse me, that this is the first phase of reform, not full implementation. There's still a significant shift in how employment rights operate in practice, and this is the first almost tranche of that. The key theme running through all the changes is managing risk, cost, and compliance in a new, significantly new employment landscape. So what I'm going to cover today are three main things: what's changed legally, what it looks like in practice for you as employers, and where the risks sit for you. So if we can look at the overview at a glance, these slides will be available post presentation, save everybody having to jot things down. So April changes at a glance: day one paternity leave, day one unpaid parental leave, a new leave, bereaved partners paternity leave. As you're all aware, statutory sick pay reform, collective redundancy protective award increases, whistleblowing changes linked directly to sexual harassment disclosures, voluntary equality and menopause action plans and menopause guidance, and trade union recognition process changes. On the 7th of April, the Fair Work Agency was established. So the changes, in a nutshell, apply to day one rights for the majority of cases. So moving on to day one paternity leave. So from this month, paternity leave becomes a day one right. Employees previously needed 26 weeks service to qualify, so that requirement has now been removed. In practical terms, it means that you're going to get more employees qualifying. Standard, you know, it's obvious there's going to be more of an immediate risk to employers. So the immediate effect is going to be on your policy wording. So every policy document needs to be amended to reflect day one rights. Manager training, this all ties in with applying any changes consistently. Your managers need to know that it is a day one right for when they get the request through. It's going to need to be in the onboarding information, and I would suggest line managers as well as senior managers, are trained on their process so that they know the eligibility notice provisions. For employees, it means basically that they can remove the gap where a job change could affect a leave request at a key moment. The main risk to you as employers is applying outdated service rules and inconsistent decision making. The inconsistent decision making is key. That's where we see the majority of the claims coming from. We've seen this in relation to flexible working, which has obviously changed. In terms of payment, as I'm sure you all know, statutory paternity pay is currently £184 or 90% of weekly earnings, whichever is lower. Although it's a day one right, they still need to give the usual notification process, usually around 15 weeks before the EWC, the expected week of confinement or childbirth. And the employer needs to confirm the eligibility and timing for the leave. So in essence, your processes and policies will stay the same, but it's the application from day one that needs amending. I would say, just before we move on to the next slide, the main risk that you may have in relation to paternity leave is determining the difference between postponing and refusing and handling the requests. As I say, I do bang on about being consistent, but it really is important. We also have day one unpaid parental leave. So not a lot of people claim the parental leave because of the reason being it's unpaid. However, it is a day one right as of now. It's different from the other statutory leave because it is unpaid and can be taken to care for a child up to the age of 18. The entitlement is 18 weeks per child, limited to 4 weeks per year. So all that's happening again is that the eligibility provision has changed. You know, it's not changing the fact that you're going to have to pay. So it's not cost risk. It's rather a litigation risk if not offered. So the three are basically, let's move to day one. If you do offer enhanced parental leave, then obviously make sure that is documented in your policy when you amend it to day one right. As I say, in all my time since parental leave has come in, I think I've only come across it a handful of times, and it's usually, you know, more of a, is it an emergency time off for dependents or parental leave? They still have to give 21 days notice, and you can, but I would caveat this with be careful, you can postpone the leave if there's a genuine business need, but you cannot refuse it altogether. So if somebody comes and asks for unpaid parental leave and you're in the middle of a really busy period, end of year, etc., you can postpone it or request that they postpone it, but you can't refuse it. Bereaved partners' paternity leave. This is brand new, completely new rights. Also a very sensitive right to have in place. Where an employee's partner dies within the first year of a child's life, The employee is entitled to take up to 52 weeks of paid leave from day one of employment. The leave must be taken in one continuous block. If the death happens close to the 52-week limit, 14 days may still be taken. If you wanted to pay, then obviously within your policy, you can have an enhanced payment. You can enhance the payment for whatever specific timescale you want to put in place, much like parental leave or any enhanced statutory payments. In terms of process, it's a difficult one because it's very hard to put an exact process in place. The employee simply needs to notify the employer as soon as practicable, and the employer should respond appropriately. So it's one of the, I suppose it's almost neonatal leave type. It's one of those leaves that will be unpredictable, and obviously to be approached in a very sensitive and appropriate manner. Key message I would give is that, update, it's brand new policy, so we need to have it updated. Everyone's handbook now needs to contain this as a statutory policy, which is what it is. High sensitivity right, I would suggest this is approached as. Tone, communication and support will be as relevant as the legal compliance. So up to 52 weeks unpaid leave. I think a question has just come in about death occurs close to the end of the leave, a short period of leave can still be taken. So if it's week 50, there's still a 14-day provision. Yes, the PowerPoint presentation will be will be sent out later. Sorry. Okay. I'm sure I'd love to see all your faces. Now we're going to talk about statutory sick pay. It's in. The change has happened. Statutory sick pay changes day one right. So there's two headline points in relation to SSP. The lower earnings limit barrier has been removed and the waiting period. So SSP doesn't have the 3 waiting days. It can start from day one of any sickness absence. SSP rate is 12325 per week, or 80% of average weekly earnings, whichever is lower. So you've got the 12325 or 80%. It's paid up to 28 weeks. There's no change there. Sorry, just bear with me while I move my screen. It's paid up to 28 weeks, as always. It's paid for what is called qualifying days. So the qualifying days are the days the employee would normally work, paid through payroll in the same way, subject to tax and NI. When I mention qualifying days, sorry, I need to go back to that one too. When I mention qualifying days, the reason this is relevant is if you have an employee who works Monday, Tuesday, Thursday, those are the qualifying days. If an employee comes to work and works for 1 minute of that working shift, they are not entitled to SSP. It's a full qualifying day that needs to be taken. Just to give you some calculations, if you like, before we look at the implications. So you work out what the employee's average weekly earnings are. If they don't have a consistent working pattern, it's an 8-week reference period, if we can call it that. And you compare the two figures. You look at the 12325 and 80% of weekly earnings, whichever is lower. So if somebody earns £200 a week, it's 80% of that, which is 160. So they will receive the 12325. If someone earns £100, 80% is £80, so they'll get the £80. It's pretty easy calculation, but obviously it has changed considerably. Although it's expressed as a weekly figure, it is calculated on a daily basis. So for a 5-day worker, it's divided by 5. Because it's payable from day 1, for a 3-day worker, it's divided by 3. So just to recap on that, and this is one of the questions that we've had, if an employee works any time at all on a shift or during the day and then goes home, they don't get SSP. For shift workers, say for instance somebody works a night shift and becomes sick during the shift, so they start at 7 till 7 or whatever it may be, fall sick at 3 a.m, they don't get SSP. They get paid up to the time that they go off. Make sure that those types of policy requirements are contained in your handbook. It just avoids any concerns that the employee may raise. They get sent home, or can I not receive SSP for the duration of my shift? No. It's a strict statutory obligation. What is the implication? Well, it's pretty simple. We've got more employees who are going to qualify and more days are going to be paid. Across the workforce, that could turn out to be a significant cost. I would also suggest that you need to look at potentially the policy for persistent short-term absence, and have something almost along the lines of a trigger point. So it's almost like the Bradford factor, but not the Bradford factor. So you need to be managing the short-term sickness absence more than you had previously. So if somebody has Monday, Friday off, it used to be the Monday, Friday-itis, you need to be calculating the amount of time they've had off and actually dealing with it, because every one of those days is going to be paid. There's also the linking of the sickness absence for SSP purposes. So these are the sort of things in the background. It's not as straightforward as saying, okay, it's a day 1, right, therefore we'll just put that in the policy and that will suffice. You need to go further into your policies and make sure that you have processes in place, particularly in relation to short-term absence. My advice to clients has been, enhance your return to work meetings. Have a return to work meeting on or after every period of absence. That will ensure that you become aware of the short-term, the reason for the short-term absence. So somebody's asked what process. So the process, if you've got somebody goes off for a week with a stomach complaint, they come back to work, you carry out a return to work meeting with them. That's the usual, are you fit for work? What was wrong? Anything we can do, see if there's an underlying reason why they're absent, and note it on file. So that employee comes back to work but goes off again in 2 weeks for another week with a different, with a sore throat. You do the same process. As it becomes more of a pattern developing, which will be evident from the return to work interviews, that's when you can look at starting the process in relation to persistent short-term absence. So they can have then, well, you've hit a point of 10 days within X amount of time. This triggers a verbal warning or first written, and follow that process. So you're not stuck with someone who is, persistently off short term. Caveat that with, do be careful that there is no underlying potential disability, but that will come to light from the return to work meetings that you're going to carry out. So as it says in this slide, you have absence reporting triggers in place, fit note workflows and internal reporting lines. If you offer contractual company sick pay, make sure that within the policy documentation you have got a provision that says it either includes SSP or excludes. Most of the time it excludes. Sorry, it doesn't. It includes SSP. So the 28 days, 28 weeks, it's early, isn't it? 28 weeks starts from the time they go off. So you're almost just topping up SSP. It is important that that clause is specific in the contract, because the process is non-contractual handbook. The entitlement is a contractual emolument and therefore needs to be included as a right. So within the contract, you will have SSP is payable from day one. If, however, you are entitled to company sick pay, this will be paid inclusive of any SSP entitlement. Again, any issues, contact your advisor and they will ensure that that's put in place. Happy to field any questions on SSP at the end, because I know it has been one of those that's caused quite a few issues recently. Okay, the next change is collective redundancy. From this month, the maximum period for protected awards linked to collective redundancy breaches is doubled. So it is now 180 days pay. It's not changing the rules, it's changing the consequences of not following the rules. So it's basically raising the cost of failing to consult properly where collective redundancy rules apply. So most of the time, if you have a collective redundancy, it's not a policy-driven process, it's a statutory-driven process. However, you need to make sure that you're ticking all the boxes. It can now result in quite a significant increase in awards. So redundancy needs planning, and I would suggest that legal engagement is sooner rather than later. Collective consultation is not a simple process, but it is a process that once you've done it, you know how it operates, and it's just a matter of ensuring that you've put these things in place before you start. So the requirement, and I think the need for that initial business rationale prior to engaging in the collective is key. From the initial business rationale, you can then move to the balloting if you don't have union recognition, You then move to the balloting, collective consultation, individual consultation, termination only after the required timescale. So it's a pretty straightforward process, but it can be complicated by selection matrix, pooling, etc. So that's why you have to get the detailed business rationale in situ before you start anything else in relation to your redundancy. 186 days pay per employee almost turns it into not just a litigation risk, but a serious financial risk and consequence. Right, the next change, excuse me while I grab my coffee, is whistleblowing and sexual harassment. Whistleblowing is a whole webinar of its own, isn't it? What is whistleblowing? It's when someone makes, in very brief terms, someone makes a protected disclosure, and that has its own definition, and it falls within certain criteria set out in the ERA. Whistleblowing is an automatic unfair dismissal. So you can claim automatic unfair dismissal if you feel that you have been dismissed for making a protected disclosure. Second claim could be that you suffered a detriment as a result of making a protected disclosure. From an employment tribunal perspective and a defence perspective, if we were to do that on your behalf, it is twofold. We would look at whether the disclosure made is protected, whether it falls within the grounds required, whether it was made in the public interest, and whether it's made in good faith. So it's quite a complicated area of law to work through, basically. And all that this has done is strengthened it and made it even more difficult. Sexual harassment has already been increased, so that we're under an obligation now to deal with sexual harassment in a proactive manner. It's now moved into the realms of whistleblowing. It doesn't take away the provisions of the protected disclosure. It just means it's easier to get it within that disclosure. So basically, it shapes how complaints are going to be framed. Where we would have treated it as a grievance in the past, we need to look at whether it's being made as part of a protected disclosure. So there is a distinction. If somebody were to say, the sales team, as a team, the culture is one that is always making remarks about women. There are elements of sexual harassment along those lines. That would potentially amount to a protected disclosure because it's a cultural issue. You are reporting something that will constitute a protected disclosure, make it to the right person. It will be protected because you're making that disclosure in the public interest, potentially, and also as part of a disclosure on legality, health and safety. It will fall within those grounds as a separate add-on, if you like. If somebody says, I have been sexually harassed by Joe sorry to anyone who's called Joe, by Joe in marketing, that may not necessarily amount to a protected disclosure. So you would need to look at them as on a case by case, effectively. What I would suggest, and to be honest, this is the case if someone lodges a grievance on sexual harassment, you're not going to then dismiss them for poor performance and link it, and there is a clear causation and link between the two. You wouldn't have done that anyway. You really can't do it now because the whistleblowing it's a very strong protection. There is no qualifying service requirement for whistleblowing either, so just always bear that in mind, and compensation is unlimited. So not only must you avoid any dismissal, automatic and fair dismissal, you must also avoid any detriment. So if somebody reports an act of sexual harassment and they are then moved into a lesser role, and I appreciate these are pretty simple examples, but you'll sort of get the flavour. If they're then moved into a less senior role, less well paid, in order to move them, let's say, out of the vicinity of the harasser, that would constitute a detriment to that individual. And on that basis, they could claim that they are being subjected to a detriment as a result of making a protected disclosure. So employers should definitely treat this as a prompt to tighten your reporting channels. Make sure your whistleblowing policy is statutory compliant. So make sure you have who they report it to, what needs to be reported, the investigation channels, anti-retaliation messaging, that's really key. If you don't have that message in it, if, for instance, you have somebody who potentially is say they're on a PIP, they then raise a point of sexual harassment by manager, the PIP continues, the PIP results in them being dismissed. They say that the dismissal is as a result of the allegations they made against their manager, which could potentially form a protected disclosure. They've suffered a detriment, i.e. being dismissed, and an automatic unfair dismissal. If, however, within your documentation, you have a clear anti-retaliation, we will not, no one is going to be subject to any detriment as a result of making a whistleblowing disclosure. That makes it clear that that's the position you hold. Then, if you make sure your internal processes are also logged, so the person who's on the PIP has had regular meetings, etc., and that is noted, then we can separate the two should it go to litigation. So it's really important that, I suppose my end slide here says, all these changes sort of interact. So it's really important that you have all the policies in separately, but that any training and reviewing and updating is done as a collective, if you like, because they will interact with each other. I think the whistleblowing this one is going to be key. The whistleblowing protections are increasing subtly over time. There is, background noise that they're going to change again. I've seen a significant increase in employment tribunal claims generally, but also in claimants ticking the whistleblowing box. Sometimes it's ticked because they tick every box. So, it's just throw enough mud at it and we'll see what sticks, without understanding what it means. But a lot of clients don't have the paper trail behind it to ensure that we can cancel any allegations. So it is really important that we revisit the whistleblowing policies that you have. Unlimited award, no service requirements. We frightened everyone half to death with that one. So we'll move on to a bit of a voluntary one so you don't have to panic quite so much. Equality and menopause action plans and menopause guidance. It's voluntary. What I would say is get something in place, even if it's not rolled out. Have a think about how you would apply. How you would apply within your business surroundings, because one size on this isn't going to fit all, is it? So I would start your general draft of any policies. As it says here, voluntary does not mean it's irrelevant. It's going to become mandatory, so we might as well get things in place now. Also, it makes, as it says here, you know, we tend to forget about, we're so busy focusing on employees and how we're going to manage all these changes internally, that this type of policy could be a benchmark in recruitment, retention, employee relations, and public scrutiny. A lot of clients want this in place because it's a good thing to have in place. Sensible approach is publish a short plan if you can. Link it to your current policies. So I suppose it's not necessarily going to be your family friendly policy section. It's going to be your equal opportunities, that type of section. And focus on practical adjustments, manager training, clear signposting, and policy updates. It's good to get it in place now, and we are going to be looking at putting a standardized policy out to our clients, but I would caveat that with every client is going to be different. If you operate a factory environment, your policy will differ from somebody who is office-based. The adjustments, practical adjustments, are going to differ. The ability to work from home, things like that. So whilst we can provide a standard policy, you do need to sit down and have a think about how you individually can apply that. So that's something to look forward to, which we will help you through. Okay, I propose that, subject to whether anyone's interested, if we can have a sort of, Saul may do a, you know, are you interested in further information on this, on the trade union recognition changes, which are, you know, we can go into quite a lot of detail on these. And I think it may be good to have a separate webinar on that to process the to go through the redundancy process and how the two interlink. So we'll take some sort of survey, hands up or something, if anyone wants any further information on this. But as you will no doubt be aware, it's becoming more of a simplified process for union recognition. It used to be the case that the Central Arbitration Centre, CAC, is still involved. They will still be engaged as part of the process, but the process itself has become significantly less onerous from a union perspective, not an employer perspective. Before this month, you could delay the process. So you could delay and challenge any union recognition. Relatively high threshold for success in ballots, and CAC were more restricted in how they could award union recognition, if you like. They were more they wouldn't be able to make a decision. It was sort of strictly, you have to have this many people. Is it appropriate for the business? What collective bargaining do we have? So all that has changed significantly. So the process is faster and recognition is going to be more likely. When I said before how none of these stand in isolation, they don't, because all the rights are moving towards employee-focused rights. The union recognition process is going to work hand in hand with that, if you like. The immediate impact is less about policy documents and more about being prepared for the changes. If we combine them with the redundancy rules, once a union recognition is established, consultation becomes mandatory and a failure can lead to significant financial penalties. So you'll see that at the bottom of everybody's contract of employment, there should be, is there a collective agreement in place? That's part of the ERA. That has to be within your section 1. If you're saying yes, you're obviously aware that you have a collective bargaining agreement with the unions that's already recognised. In that case, you have to negotiate with the unions on various points that will be set out in your collective agreement. If you go through redundancies, the unions will be involved at an early stage, business rationale stage, and they have to be involved in the collective process. Tie this in with the increased 186-day payment for failing to consult correctly, you are looking at quite a significant change in how collective bargaining and redundancy work together. The aim is clear on this. It's to provide unions and employees an easier route through the recognition process. So I can see some thumbs up are coming in for trade union recognition, and I think it would be quite a good training program to go through, and we can give you all the figures and timescales, etc. Fair Work Agency was established on the 7th of April 2026. This is a major shift in enforcement. It's more of we're moving away from waiting for litigation to enforcement requiring compliance in the first instance. So, as it says here, significant because enforcement architecture shapes how rights work in real life. So even where rights already exist, the stronger, more coordinated enforcement can change behaviour quickly. So what does that mean in practice? Previously, enforcement was fragmented, largely compliant driven, and also more litigation focused. It's more litigious, more contentious. You would have to go to a tribunal. The agency is expecting to make enforcement become more coordinated and proactive. The expectation is that the agency is going to investigate employers, enforce compliance, require back payments, and issue penalties. The key shift is that risk is no longer about employees bringing a claim, but employers may be investigated if no one complains anyway. So where you had, I guess it's where you had multi-agencies, so you had HMRC, you had the ability for the claimant to go to a tribunal, you have equal pay issues. So they're all quite fragmented departments that can then come together and investigate. This is putting it all under one heading, if you like. So it's under one heading, and they will come in and they will have authority to just bob in, if you like, and investigate. The general feeling is that there's going to be things like equal pay where the focus is going to be SSP. Are you paying correctly? Are your policies compliant? The financials, if you like, are going to be top of agenda, I would imagine. As you know, in the past, HMRC have come in to do an audit to make sure you are paying equal pay and what constitutes minimum wage, etc. Now we're going to be governed by this agency, which is going to build compliance into every process we have. So you need to consider how the agency sets priorities, specific sector focuses, what we can expect from compliance records, and how it approaches investigations and penalties. It's a new agency, isn't it? So it's almost watch this space, but not watch this space. And again, I hate to repeat myself, but it goes back to all these changes joining together to form one complete overview of how you operate employment law and, how you document your personnel files, your payroll system, how what do you offer uniforms? Is that part of the national minimum wage? All these things need to be logged, and it's so vast. I could sit here and bore you for the whole day and more, but I won't. I'll let you go do some work. But, it is something that we will be coming back to once we get some idea of how it's going to work practically. As is always the case with these things that have been set up and are new, it's almost a waiting game and waiting for someone to be the test case, which is never a good thing. But we will keep our eye on how it's, how the changes and what we're getting to see are coming into effect. And we will keep you updated on that if there's anything specific you need to do. But if you follow everything that we've spoken about so far, there shouldn't be an issue in any event, if that makes sense. We will be revisiting, because as I said at the beginning, these changes are not in isolation. We've got quite a number coming through as time goes on. I'm sure come June, July, we will be picking up the mantle of the changes to 6-month claims, which again, that's going to significantly change the landscape, if you like. So, April 2026, that's what we're focusing on. A lot of coverage has lumped it together with later changes. Let's not over egg everything at the minute. Let's take it in blocks. Let's start preparing in blocks. Otherwise, it's overwhelming for people. You've got your day job, you can't continue to put everything in place immediately. So let's cut it into bite sizes. Several of the high-profile reforms are scheduled later this year or into 2027, including changes to tribunal time limits, further sexual harassment-related duties, and reforms to dismissal rules, so fire and rehire, etc. April 2026 is an early wave, as I said at the beginning, not the finish line. So in practical terms, what do you do? Update your policies. Review your SSP systems. Revisit redundancy processes, reporting channels, and prepare for increased enforcement. Focus on consistency, documentation, and training. So as it says here, update leave policies and manager guides. I can't stress how important it is for your managers to be involved in this. You know, they're the ones that are on the coalface, effectively getting these requests, having to manage their staff. Make sure that we give them the benefit of the training to go with it. Stress test payroll and absent processes. I went through how to look at persistent short-term absence. Have a look at that within your policy and see if it does need updating. Recheck redundancy. Protected award can increase exposure. Be careful with your redundancy processes. Make sure we have them updated in line with the changes. Even if you have a pro forma, so at least you've got a tick box that you know you've done everything. Refresh whistleblowing harassment policies. Again, more to come. So let's keep doing this stage by stage and prepare for scrutiny from the Fair Work Agency. As an aside, what I suggest is when you are looking at the changes that are contractual, what I would suggest is for contractual changes for current employees, it is sufficient for you to issue them with an addendum to their contract of employment rather than reissuing the whole contract. The reason I say for current employees is new starters, obviously you can put those clauses directly into their contract. Because the changes that have come in are statutory legal requirements, so for instance, the SSP day one right, there is no requirement to consult with the employee on any variation in their contract. You can just send an addendum with, please note that the change to your contract of employment is as follows. Clause blank, you are now entitled to SSP from day one. This looks like this. So that can be sent out to everyone, get them to sign it, return it, email, whatever, put it on the personnel file. You don't have to issue a contract for everyone. I'm very conscious that, you know, that could make an immense amount of work for people. So an addendum will suffice. In relation to the handbook, again, it's the various sections that you're looking at. So if the rest of your handbook is compliant, and it's a non-contractual document anyway, the statutory elements can be inserted into the statutory section separately. So that is the end of me talking at you for an hour. Thank you very much, everyone, for your patience and coming along again to listen. As I say, we will, you know, for those of you who are clients, we will certainly be on hand to update and answer any questions you have. As I say, let's not make work for ourselves and start issuing documents for everyone. We will make sure you get the updates that you need. For those of you who are not clients, if it's something you're interested in, we can obviously have a conversation separately. I'm going to now turn to some of the questions if anyone has time. But what I'm going to suggest, and if you are not happy, just give me the thumbs down, is I will ask Saul to put together the questions, and I will do a very quick FAQ and send it out with the presentation, if that works for everyone. As I say, if give me a thumbs down if you don't like that suggestion. Oh, thumbs up. I like thumbs up. Yeah, okay. Shall I have a look at any questions now, or are you all happy to wait and I'll do them all in one go? Probably sick of listening to me, to be fair. Yes. Can I just pick up that question here? All in one go. Yay. I'll do all in one go. But there was a question there that we don't pay SSP from day one. Will it change? Yes, yes. SSP is a statutory payment. Don't confuse it with contractual payment. SSP is a statutory payment, is payable from day one, and period. Yeah. No entitlement to change. So I hope that is okay for everyone. As I say, a lot of you seem to be saying that you'd like them in one go. So I will crack on with that if that's acceptable, or if anyone has any pressing questions before we all depart, I'm happy to pick up. It's SSP, isn't it? It's the one that we're going to, if we, let me have a look, where's the chat? Sorry, now you get a really good look at my right. Enhanced sick pay, can they still only be applicable after 6 months of employment? Ooh. I suppose it's almost like you're using, it's almost making contractual sick pay a benefit, isn't it? Once you've passed your probationary period, is that the sort of thing you do, Sarah? So it's, you pass your probationary period, you are then entitled to 6 months company sick pay. That's fine. Just again, just be mindful in the background that there's no protected, there will be a protected characteristic, but make sure you're applying it consistently. But it is quite reasonable to award enhanced benefits once someone's passed probation. So I would say that yes, that's acceptable. Again, make sure it's in the contract. Limited to 28 weeks. How's it calculated when an employee works 5 days a week, but only takes 1 or 2 sick days per week? Does each sick day count individually? Yeah, sick pay is a, although it's calculated 12325, I think it's 12325, it's a long morning. It is a daily rate. Yeah, so they are entitled to it each day. You just need to do that calculation. So if they take 1 or 2 sick days per week, each sick day is counted individually. Does that make sense? That's also what I'll do is I'll answer that one in more detail on the FAQs, because there are I'll show you the calculation that you can do for that if that is any help.
Okay, I think that's it, Sharon. Thank
Pleasure,
you for
Ian.
a brilliant presentation, and thank you everyone for attending. Like Sharon says, we'll be in touch with the recording and FAQs regarding any questions that have been asked. It'd be useful just to document those in one space anyway. So thank you all for attending, and we'll see you next time.
Thank you, everyone.